Finance Management Act 2012. I beg to move, Mr. Speaker.
Next order. Order number 3, motion.
Mr. Speaker, sir, Honorable Mohamed Abdi Mohamud, the Governor of Wajir County. Mr. Speaker, whereas pursuant to Article 181 of the Constitution and Section 33 of the County Governments Act 2012, on Thursday, 27th of April 2021, the Wajir County Assembly approved a motion for the removal from office by impeachment of the Honorable Mohamed Abdi Mohamud, Governor of Wajir, and further, whereas by letter reference SPK/WCA/Senate/4/2021 subsection 1 dated Wednesday 28th April 2021 and received in the office of the Speaker of the Senate on Thursday 29th April 2021, the Speaker of the County Assembly of Wajir informed the Speaker of the Senate of the approval of the motion by the County Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly. And whereas pursuant to Section 33, subsection 3, subsection B of the County Government Act 2012 and Standing Order 75, subsection 1, subsection B of the Senate Standing Orders by resolution on Thursday, 6th May 2021, appointed a special committee comprising 11 of its members to investigate the matter on the proposed removal from office by impeachment of the Governor of Wajir County and to report to the Senate within 10 days of its appointment on whether it finds the particulars of the allegations to have been substantiated and whereas pursuant to Section 33, subsection 4 of the County Governments Act 2012 and Standing Order 75, subsection 2 of the Senate Standing Orders, the special committee has investigated the matter and tabled its report today, Monday 17th, 2021, and whereas pursuant to Section 33, 4 and 6, subsection B of the County Government Act and Standing Order 75, subsection 4, subsection B, the special committee has found that one of the particulars of the charge, namely gross violation of the Constitution of Kenya 2010, the County Governments Act 2012, the Public Procurement and Asset Disposal Act 2015, and the Public Finance Management Act 2012 against the Governor of Wajir has been substantiated. Now, therefore, pursuant to Section 33, subsection 6, subsection B of the County Government Act and Standing Order 75, subsection 4, subsection B, the Senate, after according the Honorable Mohamed Abdi Mohamud, the Governor of Wajir County, an opportunity to be heard, resolves to impeach the Governor of Wajir of the Constitution of Kenya 2010, the County Governments Act 2012, the Public Procurement and Asset Disposal Act 2015, and the Public Finance Management Act 2012. Okay. Thank you, Mr. Speaker. Mr. Speaker, I want to begin by thanking the members who served in this special committee. I want to recognize the contribution of Senator Johnston Sakaja, Senator Mwangi Githiomi, Senator Christine Zawadi Gona, Senator Susan Kiika, Senator Mithika Linturi, Senator Engineer Aligura Godana, Senator Frederick Outa, Senator Agnes Mudhama, Senator Petronira Were, Senator Isa Juma Boy. Mr. Speaker, when we held our first meeting, I was honored to be elected as the chair of this select committee, and I want to thank the members for having shown trust and confidence in me to chair the meetings. Mr. Speaker, We have worked very intensely during the consideration of this impeachment process, and this work would not have been successful without the support that this committee received from members of our secretariat. In that regard, Mr. Speaker, I want to recognize in a very special way the contribution that was made by members of the secretariat who are led ably by the Director of Legal, our own Dr. Okello, and the entire members of the secretariat from the Senate. We want to recognize their support and effort, and also extend our warm compliments for the work that they did. Mr. Speaker, I want to confirm to the House that when we were appointed, we initiated a program of activities that were adopted by this committee, as can be evidenced in Annexure 6. We took into account the fact, Mr. Speaker, that the Governor, His Excellency Mohamed Mohamud, needed to be accorded a fair hearing through his council, and we also took note of the fact that the County Assembly members of Wajir needed to be accorded a fair hearing. I want to confirm, Mr. Speaker, that the County Assembly of Wajir did appear before us, and they called, there are 3 witnesses who testified before us, and the advocate for His Excellency the Governor was accorded an opportunity to test the veracity of the evidence that was tendered before the Senate through cross-examination. I also want to confirm, Mr. Speaker, that we did also accord the Governor opportunity to appear, and he was also able to appear, give his address to the committee, and also call witnesses in response to the charges that were facing him. In this regard, Mr. Speaker, I want to thank the industry and the help that was extended to this committee by the team of able lawyers who appeared for the parties herein, led by the team that appeared for the County Assembly of Wajir, that was led by Senior Counsel Ahmed Nasir Abdullahi, and the team that was led by the defense team for the Governor, that was led by P.A. Nyamodi. This committee greatly contributed to their submissions in preparation of this report. Mr. Speaker, we proceeded to a working retreat for 2 days, for 3 days, from Friday, Saturday, all through to Sunday. And I want to also thank the members who stayed in all the sessions. Mr. Speaker, we did have a number of preliminary issues that were raised by the parties before us, Mr. Speaker, and the only one I want us to note is that there was a request to summon one witness to appear before us, but Mr. Speaker, we were not able to have that witness served with summons and appear before us, simply because of the very limited time that is available to the committee to conduct its proceedings. Later on, Mr. Speaker, I will highlight the observation of this committee on this issue of the time that is accorded to this committee. However, we were able to admit one affidavit that was filed by the County Assembly, but of course having accorded all the parties a hearing. The Speaker, the charges that were facing the Governor were basically 2. Charge number 1 was gross violation of the Constitution of Kenya, the Public Government Act 2012, the Public Procurement and Asset Disposal Act 2015, and the Public Finance Management Act of 2012. In their case before the Special Committee, the County Assembly of Wajir put forward 15 allegations in support of this particular charge. I may not go into the details of all the allegations and the observation of the committee, but in summary, Mr. Speaker, the particulars were that 1, there was failure to account for the financial resources allocated to the county. Allegation number 2 was lack of accountability in the management of county resources. Allegation number 3 in support of the charge was failure to draft medium-term strategy for the financial year 2020. Allegation number 4 was violation of Article 176, Sub-Article 1 and 185 of the Constitution. Allegation 5 was failure to establish the County Budget and Economic Forum. Allegation number 6 was failure to deliver annual state of the county address to the county. Allegation number 7 was failure to submit annual report of the implementation status of county policies and plans. Allegation number 5 was failure to establish an audit committee. Allegation number 5 was failure to seek approval of payments out of emergency fund. Allegation number 10 was operation of several bank accounts at local commercial banks. Allegation number 11, Mr. Speaker, was violation of Regulation 25, subsection 1B of the Public Finance Management County Regulations 2015. Allegation 12 was on the public finance, was violation of Section 119, subsection 5 of the Public Finance Management Act 2012. Allegation number 13 on this particular count was violation of Article 201, sub-article A, D, E, Article 2265 and Article 2271 of the Constitution of Kenya 2010. Allegation number 14, Mr. Speaker, was violation of Article 227 of the Constitution of Kenya and the Public Procurement and Disposal Act 2015. And the last allegation on this particular county was on violation of the right to health of the people of Wajir County. The Speaker, the second charge was abuse of office / gross misconduct. On this particular allegation, Mr. Speaker, the charge number 1 was abuse of power and authority. The second allegation was violation of Article 73, sub-article 2B of the Constitution. And allegation number 3, Mr. Speaker, was violation of Section 59, subsection 1B of the County Governments Act. Mr. Speaker, we were able to go through all the allegations, and because of time, I will not go into very big details on all the allegations. Safe to say that of all the 15 allegations in support of charge 1, the committee was not able to find that there was any substantiation against 13 allegations, and the same were dismissed. Mr. Speaker, the senators who have the report will see the findings of the committee on a failure to account for the resources allocated to the county of Wajir. This allegation, Mr. Speaker, was not proved, and the special committee dismissed the same. On lack of accountability in the management of county resources, the committee was able to go through the evidence that was tendered before the committee, and Mr. Speaker, the verdict of the committee was that allegation was not substantiated. Mr. Speaker, on allegation of failure to draft the medium-term strategy for the financial year 2020-2021, the committee went through the evidence that was tendered before it by the County Assembly of Wajir, and the special committee returns a verdict that it finds the allegation not proved, and therefore it was not substantiated. Mr. Speaker, on violation of Article 176, Sub-Article 1 and 185 of the Constitution, again, the committee went through the evidence that was placed before it by the County Assembly of Wajir, and it arrived at a finding that the allegation was not proved, and therefore it was not substantiated. On allegation of failure to establish county budget and economic forum, the committee, Mr. Speaker, made an observation that the governor had taken steps towards establishing a county budget and economic forum, that these had been hampered by failure of attracting qualified candidates for those positions. It was therefore the finding of the committee that that particular allegation was not proved and substantiated, and it was therefore not upheld. On allegation number 6, failure to deliver annual state of the county address, the committee finds that from the evidence that was adduced, the County Government Act does not specify the state of county address that ought to be delivered and where it should be delivered. Mr. Speaker, this committee observed that this is an allegation that has featured in virtually all the impeachment proceedings that have appeared before the Senate, and it was noted, Mr. Speaker, that going forward there is need for the Senate to consider coming up with legislation that will properly guide the implementation of that particular section of the law. Because, Mr. Speaker, when we went through past impeachment, especially the one of Waiguru, Mr. Speaker, it was not to appear before the Senate have consistently taken the view that the law does not obligate them to appear before the county assembly, and that the requirement of making an address to the county can happen even during public holidays. So we noted, Mr. Speaker, that there is a big gap in terms of what the law anticipates, and this committee recommends that the Senate should come with a legislation that will clearly address this issue. On allegation of failure to submit annual report of the implementation status of the county policies and the plans, the Speaker, having gone through the provisions of the law and the obligation placed in the hands of the governor, the committee arrived at a finding that the governor had not complied with this requirement under Section 30, subsection 2, subsection J of the County Governments Act, in that he had failed to submit the annual report on the implementation status of county policies and plans. Mr. Speaker, the committee was not persuaded that other plans that don't specifically respond to this legal obligation can be a substitute for this very clear statutory requirement. However, Mr. Speaker, the committee made an observation that not each violation or failure to observe a particular section of a statute should lead to impeachment. The committee looked at the precedent that has been set by the other past impeachments and arrived at a decision that what should lead to an impeachment of a governor should be gross violation of the Constitution. And the committee was therefore of the view that though clearly the governor had not complied with the provisions of Section 30, subsection 2J of the County Government Act, this violation, Mr. Speaker, per se does not meet the threshold for the impeachment of the governor. Therefore, though the allegation was proved before the committee, we found that it does not meet the threshold for impeaching a governor, and therefore the committee was of the view that this particular allegation should not return a verdict of removal. Mr. Speaker, we also observed that in the past impeachments, there are a number of governors who have appeared before the Senate, and we were able to cite the case of the impeachment of the governor for Taita Taveta. We also cited the impeachment of the governor for the county of Kirinyaga, and we found that in both impeachments, there were statutes that were violated by the governors who were being impeached, but the Senate returned a verdict that failure to observe the provisions of those statutes were not gross enough to warrant the impeachment of a governor. Mr. Speaker, on allegation number 8, which is failure to establish audit committee, Mr. Speaker, the committee went through this allegation and it arrived at a decision that the committee finds the allegation not to have been proved as against the governor, and therefore the same was dismissed as having not been substantiated. Mr. Speaker, on allegation number 9, that is failure to seek approval of payment out of emergency fund, the committee went through the evidence that was tendered before it, Mr. Speaker, and there was a conflict on interpretation of the law to with the Public Finance Management Act and the law that has been enacted by the County Assembly, which is the Disaster Management Act. Mr. Speaker, this committee was able to establish as a matter of fact that the provisions of the County Disaster Management Act did not have the same requirement as the Public Finance Management Act. Therefore, the allegation that the governor did not seek approval were premised on wrong provisions of the law, and if anything, it was noted that the County Assembly did note that oversight on the County Disaster Management Act, and the same has since been amended to bring it in conformity with the Public Finance Management Act, obligating now the governor to seek approval within 2 months after making payments. Therefore, Mr. Speaker, the committee was of the view that it will not be constitutional to hold the governor liable for an offense that was not an offense as at the time it was alleged to have been committed. Allegation number 10, Mr. Speaker, which is operation of various bank accounts in the local...
Let's consult in low tones, honorable senators. Let's consult in low tones, okay.
Mr. Speaker, on allegation number 10, which is operation of various bank accounts at local commercial banks, Mr. Speaker, the committee found as a fact that the county operates some accounts at the local commercial banks, but found that the operating of those bank accounts were not unconstitutional, neither were they against the law. The reasoning, Mr. Speaker, is that the accounts that are being funded align with the donor-funded projects like Danida, or for health facilities, where the health facilities have been given leeway to generate money and they bank them into specific accounts so that an assessment can be made on their sustainability. So this particular allegation, Mr. Speaker, was found not to be substantiated. Mr. Speaker, on allegation of violation of Regulation 25, subsection 1B, on the Public Finance Management County Regulations 2015, again without going into details, Mr. Speaker, the committee went through the evidence that was tendered before it, and it returned a verdict that the same were not proved and therefore were not substantiated. Mr. Speaker, on allegation relating to the violation of Section 119(5) of the Public Finance Management Act 2012, thank you. Yeah, I think, Mr. Speaker, I was on allegation 12. I was on allegation 12. And, Mr. Speaker, before the mic went off, I was making an observation that the committee went through the evidence that was tendered before it, and it returned a verdict that this particular violation was not proved. Mr. Speaker, on allegation number 13, which is violation of Articles 201A, D, and E, and Article 2265 and 2271 of the Constitution, Mr. Speaker, having gone through...
Let's consult in low tones, please. Let's consult in low tones.
Mr. Speaker, on allegation 13, the committee went through the evidence that was tendered before it. Mr. Speaker, and found that from the evidence that was placed before the committee, this allegation was not proved and the same was therefore not substantiated. Mr. Speaker, on allegation 14, which is a violation of Article 227 of the Constitution and the Public Procurement and Asset Disposal Act, again, Mr. Speaker, the committee, having gone through the evidence that was placed before it, found that this allegation was not proved. Mr. Speaker, having found that the 14 allegations had not been proved, the committee made some observations, Mr. Speaker. The first observation, Mr. Speaker, is that there is need for the members of the County Assembly to be taken through some induction on how to effectively conduct impeachments before the County Assembly, Mr. Speaker. It was the view, Mr. Speaker, of the committee that a number of allegations that were leveled against the governor relate to a number of counting officers who should take personal responsibility, especially on issues dealing with public finance management and public procurement laws. But there is a general that in every transgression happening in our counties, governors must be held to be vicariously liable. Mr. Speaker, the second observation this committee made is that there may be need, Mr. Speaker, to review the period of 10 days that is given to the Senate to receive the impeachment decision from the County Assembly and for the committee to consider and conduct a trial and render a report to the House. This is because, Mr. Speaker, like in our case, we had a situation where we issued summons for a witness to appear before this special committee, but we only had 1 day within which to execute the summons and for the witness to appear before this committee, which was not possible. So we are making a very strong recommendation to the House, Mr. Speaker, that we need to review our Standing Order 75 so that, Mr. Speaker, there is adequate time given to the committees to conduct the impeachment hearings. And here, Mr. Speaker, the committee has proposed a period of 21 days. Another observation, Mr. Speaker, is that Standing Order 75 makes it obligatory that if the committee finds that the allegations have not been substantiated, then the hearing, that marks the end of the matter. Mr. Speaker, we felt that that standing order needs to be reviewed so that even where the committee makes a finding that a particular allegation has not been substantiated, then the House, as a Senate, should be given an opportunity to debate and make a vote on a matter. Mr. Speaker, before I go to the allegation 15 on count 1, I wish to make a few comments on count number 2. Mr. Speaker, count number 2 was abuse of office stroke gross misconduct. Mr. Speaker, this matter was fairly emotive. The allegation was that the governor had abused power and authority by delegating the management of the county affairs to the First Lady of the County of Wajir. But, Mr. Speaker, when we sought for evidence to be placed before us, Mr. Speaker, we were told that the First Lady of the County of Wajir.
Order, Senator. Let's consult in low tones. You know, they are reading you will be taking a vote based on, I guess, what is being read.
So,
what you
Mr.
are hearing.
Speaker, when we sought for evidence from the members of County Assembly, Mr. Speaker, in support of this allegation, Mr. Speaker, we were given examples which caused a lot of excitement and also a lot of serious concern from the women senators that the MCAs attended a meeting at the residence of the governor where the First Lady was in attendance. Mr. Speaker, the question was, if the members of the County Assembly of Wajir elect to pay a courtesy call to the residents of the governor of Wajir. Do they expect the First Lady to take leave of absence from our own house? Mr. Speaker, if anything, the committee was of the view that if MCS visit the governor's residence, then the First Lady has a right to be there and serve food to the MCS. Mr. Speaker, we also wanted to know whether this was the official residence or the private residence of the governor. And Mr. Speaker, we were told that these meetings actually took place at the private residence of the governor. Therefore, in protection of the women folk of this country, including my own mother and my own spouse and my own daughters, Mr. Speaker, we found this allegation to be frivolous, not proved, and not substantiated, Mr. Speaker. The second particulars, Mr. Speaker, was that the governor again had met MCS in a hotel in the presence of the First Lady. Mr. Speaker, here we sought to be given minutes to confirm whether these meetings were official or not. Again, Mr. Speaker, there were no minutes. Mr. Speaker, we sought for any photos in proof that these meetings took place in any hotel. Mr. Speaker, again, we were not given any photos. So this remained a mere allegation to us, and we did submit, Mr. Speaker, and took judicial notice of the fact, Mr. Speaker, that the governor of the county government of Wajir has all the right under the sun to be romantic to his wife and to have her in his presence in his house and to go out, have coffee with her in hotels. And if anybody wants this allegation to be proved in future, Mr. Speaker, this should happen within the realms of official functions, including where there are official meetings, Mr. Speaker. If it's in a hotel, Mr. Speaker, there should be minutes confirming that the First Lady of that particular county attended the meetings and that she actively participated in the proceedings, and also that she took a vote or guided the governor on making a decision. That was not proved. The other allegation on this, Mr. Speaker, was that some money had been paid was banked by the First Lady to her personal accounts, and two, Mr. Speaker, that a person who was named as Jamal, the one that was summoned to appear before us, did bank some money to the accounts, personal accounts of the First Lady of the county of Wajir. Mr. Speaker, in support of this allegation, there was an alleged bank statement that was produced before this committee, Mr. Speaker. But we did interrogate the veracity or authenticity of that statement, Mr. Speaker, and the following issues came to light, Mr. Speaker. The person, Mr. Speaker, who appeared as witness before the Senate alleged that he got copies of those statements from the bank during the month of April this year, Mr. Speaker. But on the perusal of those statements, Mr. Speaker, it came to the attention of the committee that those statements indeed bear the signature of Ethics and Anti-Corruption Commission dated January 2019, Mr. Speaker. Therefore, Mr. Speaker, on the credibility of the witness, Mr. Speaker, the committee was not able to be convinced how a statement that was bearing the stamp of Ethics and Anti-Corruption Commission, date stamped January 2019, could have been obtained from the bank during the month of April 2021. Mr. Speaker, we tried to seek from the witness the source, the person who gave him copies of those statements, and that was not proved, Mr. Speaker. Also, Mr. Speaker, that if this matter has been pending with the Ethics and Anti-Corruption Commission for a period of 2.5 years, it is that particular body that can give a proper status on what is the status of any investigations, if any, against the First Lady of the county of Wajir. So, Mr. Speaker, all those allegations of abuse of power and authority were not proved, and the same were thus not substantiated. On allegation 2 on violation of Article 73, Sub-Article 2B of the Constitution, Mr. Speaker, again, without going into details, this is an article on dealing with Chapter 6 of our Constitution on issues of impartiality, issues of nepotism, and the likes. And on this particular one, Mr. Speaker, the committee was of the view that no evidence was indeed tendered before the committee, and there was no proof of any nepotism from the part of His Excellency the Governor, and therefore this particular allegation was not proved and the same was not substantiated. Mr. Speaker, on the third allegation, which is violation of Section 53, subsection 1B of the County Government Act 2012, the committee finds that again this particular allegation was not proved, and therefore the committee returns a verdict that the same was not substantiated. Again here, Mr. Speaker, we want to make some observation to the House that some of the charges relating to abuse of office relate to violations of the Public Procurement and Asset Disposal Act and the Public Finance Management Act. And Mr. Speaker, the committee noted that the Public Procurement and Asset Disposal Act is a standalone act that has very detailed procedures on how procurement is done in public offices, Mr. Speaker. This includes, Mr. Speaker, putting in place tender committees in a process that ends with, I think, a SIGNET which brings an end to the whole circle of procurement. So, Mr. Speaker, as a committee, we were not able to trace any nexus between the procurement of services that took place in the county government of Wajir and the governor himself. Therefore, we found that this particular allegation was not proved. Mr. Speaker, another thing that featured, Mr. Speaker, is a situation where authorities sought from the control of budget to pay particular pending bills on listed companies, on letters that are addressed to the control of budget, and consent is sought before the county can make payments. So, Mr. Speaker, the allegation here was that there is alleged corruption taking place in the county government of Wajir, because once the approval of the control of budget is given, some companies get substituted with the ones that were not appeared on the list that was approved for payment by the controller of budget. The Speaker, though we found as a fact that this may be morally wrong, we were not able to find any specific provision of the law that is violated. In fact, Mr. Speaker, we took judicial notice of the fact that this is a common occurrence in all government offices, because at times payments can change depending on the urgency of the matter at hand or change of priority. So we did make a recommendation, Mr. Speaker, that this matter should be addressed either by amending the Public Finance Management Act or through a bill that is pending before, I believe, the National Assembly, the County Prompt Payments Act. As of now, Mr. Speaker, we did not find any law that was clearly violated. And we made that observation and recommendation to the House. Now, Mr. Speaker, turning back to allegation 15 on count 1, which is violation of Article 43(1) on the right to access of health services. Mr. Speaker, this was a fairly emotive matter that was debated for almost 2 days. The Speaker, first of all, we went through other past impeachments before this House, and we made an observation, Mr. Speaker, that in a number of those impeachments, there are a number of governors who have been brought before the Senate on allegations of violations of that particular section of the Constitution, and though there has been a finding, it has not led to impeachment. And Mr. Speaker, we cited the case of the governor for Kirinyaga, where the health system in that particular county had totally ground to a halt. The Speaker, we realized that this is a common problem affecting virtually all the counties, and we were trying to balance between the right that is guaranteed to Kenyans, that is to access quality health services, and also balancing that we should not reduce the threshold of impeaching governors too low, because it should be slightly on a balance above the balance of probability, but also slightly below, beyond reasonable doubt. So, Mr. Speaker, we felt that the committee should tread with caution on this particular matter. Mr. Speaker, there were two issues that were cited by the members of County Assembly in proof of this particular charge. The first one, Mr. Speaker, is that an ambulance that was owned by the County of Wajir did break down, and instead of the governor availing enough petrol so that it's able to render services to the citizens of Wajir, citizens were called upon to fuel this particular ambulance, and there was an allegation that they even bought tires for that ambulance. Mr. Speaker, I would not want lawyers to take me to task on this allegation. We took the word of members of the County Assembly. We were not able to get clear particulars on this particular allegation, but the committee took off the view that health is very important, and that there should be more demand of accountability from His Excellency the Governor. In response, Mr. Speaker, to this, His Excellency the Governor put a very spirited defense before the Senate. Mr. Speaker, the executive submitted before the committee that they had made great strides on the improvement of the health status of the County of Wajir, and they said that in total they had 14 ambulances. They also told the committee that Wajir is a vast county, so incidences of breakdown of ambulances is anticipated, but by and large, they said that in support of the allegation that the health situation is not that bad, they had employed 50 qualified doctors, of which 25 of them have been sent abroad for further studies, and that they have been bonded to come back work for the county on their return. They gave us a chart to show improvement on their maternity, the status of maternal health care for its people. And then they also gave a mitigation that on issues dealing with COVID, Mr. Speaker, that their machine that broke down, they were not able to procure spare parts timely from South Africa due to the COVID-19 pandemic. Mr. Speaker, the other allegation was that there is a medical practitioner who passed on due to lack of oxygen in the hospital. The name was given as Dr. Sair Sumo. The defense in response to this allegation was given to the committee by Dr. Dahir Sumo, who is the County Director of Health Services. Mr. Speaker, he stated that that death was unfortunate, and he said it's not an exception for the County of Wajir. He did submit, Mr. Speaker, before the committee that the county has over 122 health facilities that are operational, which serve a population of 769. He noted that though that is not good enough, he said it is not way off when compared to other counties, Mr. Speaker. He also did state that, Mr. Speaker, they are in the process of working on the improvement of other facilities. But again, this was a statement given to us by Dr. Sumo without really going into detail. So we did not get detailed evidence. Now, on the empirical evidence that was placed before us, Mr. Speaker, it was the contention of the county government of Wajir that health had improved on antenatal clinics from 49.2% in 2017 to 86.1% in 2021. He also stated that there had been an increase in the number of children getting immunization on DBT vaccines from a low of 62.7% to 75%. He also noted that in terms of skilled birth attendants, the ones that give birth at hospitals, these had increased from a low 19% to a high of 49%. It was therefore the defense of, before I finish again, Mr. Speaker, they also did submit that that the issue of health is also facing a challenge from the managed equipment services, that is the MES program, because they are forced to procure spare parts from a particular company, and they say this is a problem that affects all counties across the country. Mr. Speaker, the other issue that pinned the county government down was the issue where a transformer of 250 kVA broke down in the county, and the county was not able to get a replacement. And it was alleged that the amount required to fix this particular machine is 5.7 million. Mr. Speaker, the committee therefore took the view that the government had not acted prudent on this matter, and that this is a matter where an example ought to be set. Mr. Speaker, I want to make a confession to the House that for us who are lawyers, this was not easy, Mr. Speaker, because we really need to be careful when we set the threshold on impeachment, so that it is not on a balance of probability, but on above again beyond reasonable doubt. There was a fear, and I hope this House will be able to debate that if this particular clause 43(1) was to be impeached against governors, Mr. Speaker, is that there is no governor who may be in office. It may affect all governors in office. Therefore, Mr. Speaker, I invite the House to a robust debate on this particular allegation, and also on the threshold that this House has set before on issues of impeachment of governors, so that, Mr. Speaker, there is consistency. There was an observation made by the committee, Mr. Speaker, that we need to be careful so that we don't expose ourselves as having violated the provisions of Article 27 on discrimination, in that there are a number of governors that have appeared before the Senate with the violations touching on Article 43(1), but who have gone scot-free. But I want to invite the House to have a robust debate on this particular one, but the committee finally arrived on a finding to impeach His Excellency Governor for Wajir County on this one allegation, which is on count 1, allegation number 15. Mr. Speaker, we made also other general observations that we felt should not reach this House, that the MCAs should exercise their oversight role at the county level. Mr. Speaker, including this particular case where there were accusations leveled against specific counting officers, county accounting officers, that is the chief officers. The Speaker, we have made an observation that MCAs should take note that it's not the constitutional mandate of this House to deal with violations of county accounting officers. And this is a matter that can be dealt with by the counties at the county level. Mr. Speaker, on issues of reshuffling of chief officers that featured, again, the committee made an observation that these are matters that should really not find their way to the committee, as the county assembly need to draw a distinction between the work of the county public service board and the work of the governor within the counties. So in total, Mr. Speaker, I move, Mr. Speaker, that the House confirms our report, Mr. Speaker, that allegation count 1, allegation number 15, has been proved. But before I finish, Mr. Speaker, there is another issue that arose on public participation, Mr. Speaker. Mr. Speaker, the committee made an observation that on recall for elected members of parliament, senators, MPs, MCAs, the citizens cannot successfully prosecute a recall clause unless they collect signatures from the citizens of either the county, ward, the constituency, Mr. Speaker, or the county. So, Mr. Speaker, we made an observation that going forward, this House should consider that the task of impeaching governors should not be left solely at the discretion of members of county assembly, that there should be a law that obligates those who are proceeding with impeachment motions against governors. They should also collect signatures from members of that particular county who elected the governor. So with those remarks, I want to ask my good friend, Senator for Marsabit, Senator Adugura, to second. I thank you, Mr. Speaker.
Thank you, Mr. Speaker. Mr. Speaker, I'd like to second this special committee report on the impeachment of Governor for Wajir. Mr. Speaker, the County Assembly brought many allegations under 2 charges, and I'd like to advise the County Assembly that they are the first line of oversight, and in case there are issues, they have to first perform their duties before they bring these allegations to the Senate, because the law is very clear. If it's a county executive committee member or a county accounting officer who's a chief officer who has not performed his or her duties, then they have the powers to summon or to invite. And once they find that person culpable, then they have also the powers to recommend to the governor. They can impeach that person and have him out of office and recommend the same to the governor. In the event that maybe the governor has refused to take the ruling of the House or implement the ruling of the House, then that could be an issue which can be taken against the governor. Like in the first case of impeachment of Governor Wambora, which was, among the other charges, was that he refused to sack the county secretary who was impeached by the county assembly. So in that case, they have done their part. It was the governor who was not ready to do his part. That's why it was part of the impeachment grounds. But in this case, the county assembly brought issues which could easily be attributed in law to have been the failures of the county executive members or accounting officers, which cannot be connected to the governor. That is why in some cases where we could find, yes, as a matter of fact, the law has been broken somewhere, but it's not the governor, so we cannot impeach the governor on that. That's why we said not substantiated against the governor, but it may have happened. Then the other issue is the auditor's report, because some of these allegations are also based on the auditor's report. The county assembly also has that responsibility to take up the auditor's reports and summon the relevant county executive committee members to address issues raised in the auditor's report, so that if somebody has broken the law, then that person will be held accountable. But transferring that one as an allegation to the Senate also becomes difficult to pin the governor or to connect to the governor, because it is very clear in law that it's a particular officer. I'll cite the case like under allegation 14, which there are many procurement issues. Yes, we looked at them and found that here, in particular instances, the law has been broken. For example, the issue of ugali, where a known item, a common user item, has been overpriced. Instead of, they said 1,600 shillings per bale, it was procured at 3,500, which is a very clear case of a violation of the law. If you look at the Public Procurement and Asset Disposal Act, at section 106(4), it says that where the lowest price is above the prevailing market rate, the request for quotation shall be cancelled or terminated in accordance with cancellation and termination procedures in this Act. So if you know the price of an item and the quotation, the prices is very high like this one, then the next action for the procuring officer was to cancel that, but it was not cancelled. So what does the law say? If you go to the same Public Procurement and Asset Disposal Act, Section 54, Part 4 says, in case of that, then the public officers involved in transactions in which goods, services, works procured unreasonably inflated prices, in addition to any other sanction prescribed in the Act, the regulation, then will be required to pay the procuring entity the loss resulting from that. So the law is very clear. If a breach has occurred, then it's the public officer involved in that procurement. So I'd like to urge the County Assembly of Wajir to take it up and check, yes, the law has been broken, but by an individual who is within their purview in terms of oversight, whom they can take action against. But taking that and transferring it to the governor will not, we will not get that connection, so we cannot substantiate as a charge against the governor. So I'd like to urge the county assemblies to look at the auditor's report, digest it, summon the relevant officers, and make them explain whatever is there, so that in the event they have taken action and the governor is not implementing, then that could be an issue which can be taken against the governor, because it's him now not acting after the breakage of law has been established against one of his officers. Mr. Speaker, so in those cases, the committee advised that the county assembly takes it up with the relevant public officers under them, so that they can remedy those breakage of law at that level instead of holding it against the governor. Mr. Speaker, some observations which I'd like to make, which some of them has been made by the mover, is that the issue of the time in terms of carrying out this impeachment process is not enough, even for the committee, which takes 10 days, which is even worse in case of preliminary, which will just take maybe the whole preliminary can sit in 2 days and justice will not be done. So I think it's for us to look at our standing orders and amend them so that we have enough time. The other one is the issue of Standing Order 75-4A, in which it says that if the special committee has found no allegation against the governor to have been substantiated, no further action is taken. My understanding is that, Mr. Speaker, the special committee, just like any other committee of the House, is working for the House. So whatever they will have established should be brought to the House, and the final say should be with the House. So in this instance, even if the committee found there will be no allegations substantiated, the report should be submitted to the House and debated, and maybe at a higher threshold, let's say maybe at a 2/3 majority, the House can overturn the findings of the committee. That way, the House will be comfortable working through the committee, because the committee will not terminate the proceedings using this Standing Order 75-4A. Mr. Speaker, there are issues which, like in the charge of abuse of office, very emotive issues have been raised, but unfortunately, or fortunately as Senate, we'll have to ask for facts before we can make any conclusion. That is why we insisted that any information provided should be admissible to us, like in the case of the bank statements, which we tried to inquire how it was acquired and all that, and the witness was not ready to give us any information, so we could not rely on it. Otherwise, when the county assembly decides to prosecute its case, it must give us enough information for us to make the decision we like or they want us to make. It's for them to push and argue their case. It's not for us to argue their case for them. Mr. Speaker, in the case of coming to the last allegation 15, which has been substantiated by the committee, health is a devolved function, and it's one of the major cornerstones of devolution. So when the health system in a county is going down, and that county gives more than 20% of its budget to health, and you're hearing strikes by county employees, then you are told main equipments in the main hospital are not working, and especially in this COVID period, you are told a budget of 194 million was given to the governor to take care of this COVID period, and among the things you expect is the oxygen plant to be working, you expect all the other equipments to be working, then you are told somebody, a health employee, passed on because there was no oxygen, the oxygen plant is not working. Then you ask, what is the problem? There is power problem. What particularly? A gadget of 5.8 million was required to connect power to have the 1,000 kVA generator to be connected to power all the equipment in the hospital, and you are told that was what's missing. Then you ask yourself, what happened to 194 million so that it could not procure a 5.8 million gadget, which is a matter of life and death for the people of Wajir. So based on that, we found that is a very serious issue, and there is no way we would have said that that is not gross. Otherwise, what will you be doing as a governor if your people are dying and you could not fix that kind of an equipment? So, Mr. Speaker, based on that, we said that that is a gross violation, and that's what we find. We would like the House to find out and agree with the committee. And on the issue of, there was this issue of payment of contractors. This is under allegation 14, charge 1, where a county will send a requisition to the controller of budget to authorize withdrawal of funds, and that requisition has a list of the contractors to be paid. Then, when money is requisitioned and obtained based on that request, the government officer, the county government officer here, said very clearly that they don't have to pay the same people. So what was the reasoning of using that list? Requisitioning for payment using that list if it will not pay the same people. That is an issue. I'd like this House to take it up with the controller of budget and tell us whether that is the position in law. Because what the chair said is morally it's wrong, but we don't see any law which prohibits that. But personally, I feel even the law has to be in line with that morality, because in this country, we had a very long history of misuse, misapplication of public funds, and that is why all these laws are in place, and that's why even the Office of the Controller of Budget has been created to streamline all these processes. Now, if we follow the law halfway, once you get the money, you misapply it again, then that law needs to be checked. And we stopped at actually saying that somebody to be held accountable because of that doubt in law, which we need to confirm from the Controller of Budget, so that we get the very clear position, so that this abuse of that particular requirement does not continue, because it's happening in many counties. Mr. Speaker, with those few comments, I'd like to second this special committee report and urge the House to adopt it. Thank you.
Honorable Senators, I now propose the question, which is that whereas pursuant to Article 181 of the Constitution and Section 33 of the County Government Act 2012, on Tuesday, 27th April 2021, the Wajir County Assembly approved a motion for the removal from office by impeachment of the Honorable Mohamed Abdi Mohamud, Governor of Wajir County. And further, whereas by letter reference number SPK/WCS/Senate 2021, dated Wednesday, 28th April 2021, and received in the office of the Speaker of the Senate on Thursday, 29th April 2021, the Speaker of the County Assembly of Wajir informed the Speaker of the Senate of the approval of the motion by County Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly. And whereas pursuant to Section 3B of the County Government Act 2012 and Standing Order number 75-1B, the Senate by resolution on Thursday, 6th May 2021, appointed a special committee comprising 11 of its members to investigate the matter on the proposed removal from office by impeachment of the Governor of Wajir County and to report to the Senate within 10 days of the appointment on whether it finds the particulars of the allegations to have been substantiated. And whereas pursuant to Section 33(4) of the County Government Act 2012 and Standing Order number 75-2, the special committee has investigated the matter and tabled its report today, Monday, 17th May 2021. And whereas pursuant to Section 33(4) and 6B of the County Government Act and Standing Order number 75-4B, the special committee has found that the particulars of Charge 2, namely abuse of office and gross misconduct against the Governor of Wajir County, has not been substantiated. And whereas pursuant to Section 33(4) and 6B of the County Government Act and Standing Order number 75-4B, the special committee has found that one of the particulars of Charge 1, namely gross violation of the Constitution of Kenya 2010, the County Governments Act 2012, the Public Procurement and Assets Disposal Act 2015, and the Public Finance Management Act 2012 against the Governor of Wajir County has been substantiated. Now, therefore, pursuant to Section 6B of the County Government Act and Standing Order number 75-4B, the Senate, after according the Honorable Mohamed Abdi Mohamud, the Governor of Wajir, an opportunity to be heard, resolves to impeach the Governor of Wajir County on the ground of gross violation of the Constitution of Kenya 2010, the County Government Act 2012, the Public Procurement and Asset Disposal Act 2015, and the Public Finance Management Act 2012. Senator Kajwang Moses.
Mr. Speaker, I'm rising on a point of order. Our duty today was to receive the report of the special committee, which is before us, which is a remarkable report that was signed over well. It was signed by all the members of the committee. Our other duty today was to listen to the governor in his defense. The other duty was to consider all the facts before us and finally to take a vote. I just needed your guidance whether this is a time where we are calling the governor so that we don't have to debate before we have listened to the governor. Thank you, Mr. Speaker.
Our procedures and the way we've done it in the past is that the governor has the last word after you have made your contributions, those who want to contribute. What's your point of order? Who is that, Senator? You're not on.
Mr. Speaker, then I move that we proceed to hear the governor, unless any member has a burning issue to debate. Thank you.
I can see Senator James Orengo.
Mr. Speaker, I think there's some good reason in what Senator Kajwang is saying, because it must never be lost to us that now we are like the court itself. We are going to reach a verdict. And before we say everything good or bad, maybe we may be persuaded either way. And I think it would be important to give the governor a chance. And then we will now be contributing to the motion on the basis of what we have heard from him, as against us talking and then eventually the governor speaks and we cannot come back and again comment on what he has said. So I know that the procedure may be there, from the past. But I don't think it's well articulated in the standing orders that the governor is the last person to speak. But even if he was the last person to speak, I think the rules of natural justice would apply, because we are not accusers. We are not accusers. We are not accusing the governor. We are hearing the case of the governor and then making the decision. We have heard the committee and its finding, and maybe the governor may have a comment on that report, and then we can debate the motion on the basis of what we have heard from the governor.
Senator Chilayako.
Thank you, Mr. Speaker. Mr. Speaker, this is a matter that this House rightly asks you to apply your discretion and depart from the precedents. It's not proper for us to give our opinion, to give our position, hearing any additional facts that the governor may have. Lies on the face of Fair Administrative Actions Act when we comment before hearing the full story. So, Mr. Speaker, just like Senator Kajwang and Senator Orengo, I implore you, plead with you to depart from the tradition or convention and have us hear the governor, so that we can contribute from the position of knowledge and from the position of facts. Thank you, Mr. Speaker.
Senator Wamatangi.
Mr. Speaker, I rise also to support the position as expressed by my colleagues, and indeed as proposed by Senator Mwenyehaji Faki, Mr. Speaker, because for all intent and purposes, Mr. Speaker, whatever the governor will be saying at the point when he is invited, be it the equivalent in court proceedings of either mitigation or defense, Mr. Speaker, it is supposed to help his case. And because, Mr. Speaker, the people who will be making the decision, finally, after hearing what the governor has to say on the charge, Mr. Speaker, that has been substantiated. Mr. Speaker, I want to support the position that the most prudent thing to do, so that, Mr. Speaker, the process can be as flawless and as justice-filled as it should be, Mr. Speaker, is to allow the governor to come to the House and, Mr. Speaker, make his remarks or his comments, Mr. Speaker, indeed, or mitigate or defend himself, that we should be full and knowledgeable of all the things that, Mr. Speaker, the governor would want to say, and then we can proceed to make a decision. So, Mr. Speaker, I support the position that we invite the governor to make his comments.
Senator Haniri.
Mr. Speaker, Senator Faki moved that we hear the governor. He was not seconded. I want to be on record that I'm seconding him. Mr. Speaker, the standing orders are not very clear on this particular procedure. It just says that having substantiated, the Senate shall, after according the governor an opportunity to be heard, vote on the charges. So the matters have been substantiated, some, and I think it is only fair that before we take a vote, and of course a vote will be preceded by debate if there are those who wish to make some contributions and observations, it is only fair that we listen to both sides. My colleagues have put it very well, the lawyers who have spoken before me, that in this particular matter, we elect the judges. So we cannot give our verdict having only listened to one side of the story. So I think it is just fair that at this stage we bring in the governor to make his address. Then you can now open to members for debate and voting. Thank you.
Senator Cherargei.
Thank you, Mr. Speaker. Maybe to add on that, and before we decide, because we have a committee report already that has been tabled, number one. So I don't know when the governor speaks, because I've also read the standing orders. When the governor speaks, should we, in part of the report, when we are reacting, is to the point. One is.
Yeah.
Yes.
Senator Murkomen, you are entering with a lot of drama. Yes, Senator Chararge.
So, Mr. Speaker, I've read the standing orders, and it is not clear, as Senator Kaniri has said. But my opinion is that there is a report that is already here. We want the governor to speak, but I think to be neat, it is better to react and respond to what the governor is saying inter alia with the report that has been tabled by the committee, so that we can be neat, then we react and vote. I support Mr. Speaker, sir.
Senator Cheriot.
Thank you for this chance. The right to a fair trial is a cardinal principle in this constitution of ours, Mr. Speaker. What will be a fair trial for the governor in light of what has happened, bearing in mind our constitution, the standing orders, and all matters before us? At 2:30 when we walked in this afternoon, Mr. Speaker, those of us who are not members of this committee received the report. The report almost has 300 pages. I know Senator Wetangula has before tried to convince the House that lawyers have a formula for reading faster than the rest. There is no scientific evidence to confirm that. And we can put even the lawyers in this House through a test of the 300-page plus document. And they will do just as the rest of all of us, Mr. Speaker. So what will be a fair trial to the governor for Wajir? I think I want to agree with the proposal by Senator Mohamed Faki, as seconded by Senator George Aniri, that in addition to reading through the report, Mr. Speaker, giving the governor a chance to make his case before us, especially at this point where he knows the verdict that the committee have arrived at and the conclusions that they made, will be a good place to start the debate leading to our decision making as a Senate. Because, Mr. Speaker, what will happen is that he will explain himself, and as such, as seated as a jury, we will listen to his rebuttal to what the report accuses him of. Then afterwards, each of us will be free to air their findings in whatever, whether they agree with the committee report or with the defense or that the governor will have put up here by himself. Therefore, Mr. Speaker, I support this proposal that let us listen to the governor at this particular point. Then later on, we can have a debate having listened to both parties. Thank you, Mr. Speaker.
Senator Murkomen.
Thank you, Mr. Speaker. The proposal to bring the governor before our debate, Mr. Speaker, I think again is one of those very important innovations that we are putting forward after learning from the past experience. Because, Mr. Speaker, the governor already knows his verdict, the verdict of the committee. Coming before us is like an appeal. So it's better he makes his case first, Mr. Speaker, before now we can sit and converse and make a determination. Because if I will have made my position known during the debate before the governor speaks, the Speaker, it becomes even contradiction for me now to vote after that, having been convinced by the governor, and yet I'm on record having taken a particular position. So whereas this is the first time we're going to do this, I think, Mr. Speaker, it's a better way to do it. Governor speaks first, then we have an opportunity now to consider what would be, in my opinion, part of his appeal, and then apply the same to our debate and the vote. So I think that will be, this has been unique in this governor's trial from the time we started with the committee, the process with which we identify the committee members. And I don't think, with your permission, Mr. Speaker, this would be a better way of doing it. Thank you, Mr. Speaker.
Senator Wetangula.
Thank you, Mr. Speaker. Mr. Speaker, what we are faced with now bears us out that law is indeed dynamic. Dynamic to the extent that every other day you encounter something new. Previously, Mr. Speaker, we normally, like in the Wambora impeachment, the report is tabled, moved, seconded, debated, then we hear the governor, then we retreat into something called camera, discuss again, and vote public. I'm persuaded by Senator Faki and those who have spoken. Our constitution says justice shall be dispensed without any due regard to unnecessary technicalities. And given what we have, Mr. Speaker, I know that some lawyers here may hold a different view, but having listened to the mover and the seconder, who listened to first-hand evidence and who have brought a report, apart from our personal opinions on the report, none of the members here is going to advance an evidential argument other than what we have. To that extent, Mr. Speaker, then, vague as it looks, the proposal by the distinguished senator for Mombasa, supported by other senators, falls squarely within the ambit of Standing Order 75 4B. If the special committee reports that the particulars of an allegation against the governor have been substantiated, the Senate shall, after according the governor an opportunity to be heard, vote on the charges. This particular standing order doesn't even seem to anticipate debate, although we have been debating and we will make our comments along the way. So it might be good, Mr. Speaker, in my view, to hear the governor, and those who have proposed as such, I think, have a point. A departure as it may be from our previous proceedings, but it's not in violation of any standing order. It is in fact in sync with the Standing Order 75 4B. So I concur that we can call the governor and Article 50 of the Constitution. Yes, that talks of fair trial. So, Mr. Speaker, I urge you to, in making your ruling, to consider the things we have said, and if the governor is around, we hear him.
Okay, order, senators. Senator Cherargei. Okay, Honorable, you are all over the House. Honorable Senators, I've heard you, and I want to use discretion of Standing Order number 1 and put a question, a voice question, following what Senator Faki has proposed and seconded by Senator Haniri. Ask that as many are of that opinion that the governor comes now before debate, say aye. Aye. As many are of a contrary view, say nay. The ayes have it. So we will have the governor, let him come. The governor or his lawyer will give you, to start with, I will give him 30 minutes. Governor, are we ready? Okay, the governor will be heard through his lawyer. So you are welcome. I've said, giving you an initial. I'm sure. Yes.
Members, my name is Ndegwa Njiru. With me, with my colleague, my line friend, Mr. Mburu. We are here on behalf of the governor. However, spoke to him when this session began. Mr. Speaker, sir, he was slightly taken ill, but he has been able to recover and is on his way. He has advised me to come and seek your indulgence, to at least indulge him for about 10 to 15 minutes, so that he can be able to avail himself. For one reason, Mr. Speaker, sir, that the governor who is on trial and deserves to be heard. If it so pleases you, Mr. Speaker, we so seek your indulgence. Then you shall allocate time to us, because we intend to give him about 5 minutes. Then we shall do the sum up of our submissions. Much obliged.
That's okay. It's granted. 15 minutes. What's your point of order? Senator Murkomen, so that I make a decision.
Thank you, Mr. Speaker. Considering the request that came from the governor's lawyer, Mr. Speaker, in this very difficult time, it is not, Mr. Speaker, surprising to find anybody falling ill, Mr. Speaker. It's possible in this very difficult trial. But now I'm asking, are we not, we should find the right standing order with which we adjourn for a certain period of time. And Mr. Speaker, is it not in order for either minority leader or majority leader to move a motion for adjournment, Mr. Speaker? Is it purely a discretion of the Speaker?
Yes.
Because I thought the leader should
no, Senator Murkomen, what I will do is use standing order number 1 and just suspend the House for 15 minutes, so that we come back at a quarter to 5. Okay. Oh, quarter to 6.
The Speaker of the Senate, Honorable Ken Lusaka, has yet again directed that the House takes a short break, that is a break of 15 minutes. This is to allow for the governor for Wajir County